This rights movement for corporations, for the rich, the powerful, and the fortunate, has been pursued in a manner, deliberate infiltration of the judicial branch of government, that should concern anybody who respects the law, and in particular, respects our Supreme Court. The Republican effort to capture that institution for those interests has been a remarkably aggressive and surprisingly explicit effort. Usually, political efforts to capture great public institutions come, as it were, in sheep's clothing. But this wolf came as a wolf. Consider, for example, the official Republican Party platform of 2000, which applauded Governor Bush's pledge to name only judges who have demonstrated that they share his conservative beliefs and respect the Constitution. All that was left out was that they should be willing to bend the law and overturn precedents to impose those beliefs. The pattern's not complicated. America's big corporate interests fund Republican candidates for office, and those corporate interests want those Republicans to help them. That's as old as politics. Republicans, once elected, make it a priority to appoint judges who want to help them. Judges who may give obligatory lip service opposing judicial activism, but will actually deliver on core Republican political interests. The conservative bloc of judges overrules precedent and 100 years of practice to open the doors to unlimited corporate political spending. And corporations can now give ever more money into the process of electing more Republicans. Connect the dots. Republicans are the party of the corporations. The judges are the appointees of the Republicans, and the judges just delivered for the corporations. It is being done in plain view. The Washington Post recently explained that the U.S. Chamber of Commerce is now free to spend unlimited amounts of money on advertisements explicitly attacking candidates. The Chamber of Commerce already had announced a, quote, massive effort to support pro-business candidates in November. So the response from the Republicans, as reported by the Washington Post, should come as no surprise. Republican leaders cheered the ruling as a victory for free speech and predicted a surge in corporate support for GOP candidates in November's midterm elections. Now that the court has taken the fateful step of forbidding any limits on corporation spending to influence campaigns, we can expect to see corporate polluters under investigation by the Department of Justice, running unlimited ads for a more sympathetic presidential candidate. Financial services companies spending their vast wealth to defeat members of Congress who are tired of the way business is done on Wall Street. Defense contractors overwhelming candidates who might dare to question a weapons program that they build. The court was so eager to give artificial corporations the same rights as natural, living human beings that it virtually overlooked foreign corporations. The activist Republican majority leaves wide open the possibility of a constitutionally protected right to influence American elections being held by a Saudi oil company interested in American energy policy, a third world clothing manufacturer opposed to American labor standards, a foreign farm conglomerate concerned about America's food safety rules. Is the five-man conservative bloc's fealty to corporate power so absolute that they could not bring themselves to say that the First Amendment doesn't protect foreign companies wishing to drown out the voices of American citizens? Mr. President, our government is of the people, by the people, and for the people. By refusing to distinguish between people and corporations, the Citizens United opinion undermines the integrity of our democracy, allowing unlimited corporate money to drown out ordinary citizens' voices. So look out for a government of the CEOs, by the CEOs, and for the CEOs, who now have special privileged status. Not only may CEOs use their personal wealth to influence elections, they now get the added megaphone not available to regular citizens of being able to direct unlimited corporate funds to influence elections. CEOs now have twice the voice or more of everyday Americans. I won't belabor the record here because it is something of a technical matter, but before I conclude, I have to say from a point of view of judicial practice, the majority opinion is disturbing in several ways. First, it uses rhetorical devices that are more consistent with polemic than judicial determination, vastly overstating the opponent's arguments, using false analogies, knocking over straw men, indulging in selective quotation, and unsupported fact-finding. Just one example. The conservative bloc found as a fact, and remember, fact-finding is not the proper province of an appellate court in the first place. But here's what they found. We now conclude that independent expenditures on elections, including those made by corporations, do not give rise to corruption or the appearance of corruption. They just decreed that. So a company comes in, drops a couple of $1 million in a smear campaign against an opponent at the bitter end of the race when it can't be answered. And the next thing you know, the person that they defended against the opponent is in their pocket. No appearance of corruption? Well, the Supreme Court's decided it. No appearance of corruption. That's clear to them. Furthermore, the appearance, another finding of fact by this block of judges, the appearance of influence or access, furthermore, will not cause the electorate to lose faith in our democracy. The appearance of influence or access will not cause the electorate to lose faith in our democracy. They made that up out of whole cloth. There are hundreds of thousands of pages of findings to the contrary in the record of previous Supreme Court decisions that they overruled, but nope, they made these unsupported findings. It's novel, it's naive, and it contrasts with the actual findings of this Senate 100 years ago, which said the following, I quote, "The evils of the use of corporate money in connection with political elections are so generally recognized that the committee deems it unnecessary to make any argument in favor of the general purpose of this measure. It is in the interest of good government and calculated to promote purity in the selection of public officials. The evils of the use of corporate money in connection with political elections was so generally recognized 100 years ago that the Senate committee working on that legislation deemed it unnecessary to make any argument in favor of the measure. It was too obvious. And yet now this appellate tribunal has made fact findings that that's all just wrong. Moreover, the small band of conservative justices departs from regular judicial practice by relying for precedent on its own members' previous concurring and dissenting opinions, as if they were their own little court, building a scaffold of arguments alongside the law in wait for the right case with a sufficient majority to abandon the law and jump to their scaffold of argument. As Justice Stevens accurately pointed out, the majority opinion of the right-wing bloc is essentially an amalgamation of resuscitated dissents. Finally, and most disturbingly, the Chief Justice evaluates precedent in terms of whether his 5-member bloc objects to it. He's surprisingly outright about this. He says this: stare decisis, the principle that a settled question is settled, that it stands decided. Stare decisis effect is diminished, he says, when the precedent's validity is so hotly contested that it cannot reliably function as a basis for decision in future cases. And he later continues, the simple fact that one of our decisions remains controversial does undermine the precedent's ability to contribute to the stable and orderly development of the law. As anybody looking at this can see, it is a completely self-fulfilling theory. And it allows the 5-man right-wing bloc on the court to gradually undermine settled precedent, to tunnel under it with quarreling objections, hotly contesting it, perhaps even to accelerate the process of undermining. And then, at some point, decree that the settled precedent is no longer valid because they have quarreled with it. And now it must fall. There can be little doubt that the conservative bloc is laying the foundation for future right-wing activism in a seemingly deliberate and concerted effort to expand its political philosophy into our law. And of course, always, 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 the dramatic changes observably fall in the direction of the Republican Party's current political doctrine and interests. I will close by quoting Justice Stevens, who I think puts the fundamental issue of the Citizens United majority opinion in clear relief. At bottom, he says, the court's opinion is a rejection of the common sense of the American people, who have recognized a need to prevent corporations from undermining self-government since the founding, and who have fought against the distinctive, corrupting potential of corporate electioneering since the days of Theodore Roosevelt. It is a strange time to repudiate that common sense. While American democracy is imperfect, Justice Stevens concludes, few outside the majority of the court would have thought that its flaws included a dearth of corporate money in politics. I thank the chairman. I yield the floor.